guys, welcome back to HR Help Us. Today we're going to dive into the Super Bowl of gender discrimination. This is a lawsuit against Walmart Stores Inc. versus Dukes. If you have not heard the story, let me tell you about it. So imagine trying to organize 1.5 million women for a class action lawsuit. I mean, to me, that sounds like an HR nightmare with a side of legal chaos, right? Am I the only one? Okay, that's exactly what happened with Betty Dukes and her co plaintiffs. That's what they did. They basically called out Walmart for systematic pay and promotion biases. But spoiler alert, the Supreme Court was not buying the one size fit all approach. What followed changed the future of class action lawsuits forever. So let's unpack the receipts, shall we?
America, land of opportunity. Unless, of course, you work at Walmart and you're a woman trying to get promoted. Today, we're talking about Walmart Stores Inc. v. Dukes, a 2011 Supreme Court case that said, sure, you can be discriminated against, just don't all complain about it at once. Betty Dukes worked at Walmart in California. She believed she was being passed over for raises and promotions because she was a woman. Spoiler, she was not alone. She sued Walmart, but not just for herself. This was a class action lawsuit on behalf of 1.5 million women. That's not a lawsuit. That's a legal flash mob. The claim? Walmart had a pattern of paying women less and promoting them less often than men. There was no official memo saying women get less. But apparently, discrimination was more of a vibe. Local managers had the freedom to do whatever they wanted. And what they wanted, allegedly, was to give raises to guys named Brad who showed up late but had potential. And that's where the legal fun begins. The case made its way to the Supreme Court. Walmart argued that you couldn't lump all these women together in one case. Why? Because they didn't all have the same story. The court agreed. In a 5-4 decision, the justices said the group was too big and too different to qualify as a class. Even if thousands of women felt discriminated against, their experiences weren't similar enough to sue together. It's like saying, yes, you all got food poisoning, but unless it was the exact same bite of potato salad, you need to sue separately. Justice Scalia, writing for the majority, said the women didn't point to a common Walmart policy that was discriminatory, which is ironic because not having a clear policy was kind of the problem in the first place. Justice Ginsburg dissented. She said the decentralized decision-making was exactly what allowed bias to happen, duh. But in the end, the majority ruled and the class action was shut down. So what does this all mean? It made it much harder to file giant class action lawsuits against giant companies. You now have to prove your group has a lot in common, like suspiciously identical stories, before you can sue together. Betty Dukes passed away in 2017, but her case lives on in legal history and corporate HR presentations everywhere. So next time you save $1 on paper towels at Walmart, remember, you may be getting a deal, but someone else may have paid the price. And no, you can't sue about it unless you're very, very specific.
So, what did we learn from Walmart versus Dukes? Besides the fact that you cannot wing it when it comes to class action lawsuits, because as you saw, the legal technicalities can basically bulldoze even the boldest fights for equality. The case didn't deliver the win the plaintiffs hoped for, but it did crack open conversations on corporate accountability, ethical leadership, and I would say and the power and limits of collective action. Because at the end of the day, policies beats bias, and HR decisions echo all the way to the courtroom. So I thank you so much for following HR Help Us. Please don't forget to like, share, and subscribe.